Howdy, I'm Bryan Holman, attorney at the Woodlands Law Firm. Today I want to speak with you about a recent federal court decision that, although it was decided in the Southern District of New York, has immediate and profound implications throughout the United States. In United States v. Heppner, the court ruled that documents generated by a defendant using a publicly available artificial intelligence platform are not protected by the attorney-client privilege or the work product doctrine. This ruling is among the first in the country to confront how our long-established privilege rules apply in the era of generative AI. In Heppner, the defendant, after receiving a grand jury subpoena and retaining counsel in a federal securities fraud case, used a publicly available AI platform, Anthropic's Claude, to generate approximately 31 documents outlining defense strategies and legal arguments. He later transmitted those documents to his attorney. When the federal agents executed a search warrant at his home, they seized those AI-generated files. The defendant's legal team claimed that the documents were privileged, but the government challenged that assertion. To understand the court's ruling, it helps to revisit what attorney-client privilege and work product protections are. Attorney-client privilege protects confidential communications between a client and their lawyer for the purpose of seeking or providing legal advice. But when a client communicates through a publicly available AI platform, such as Claude or ChatGPT or Gemini or many of the others, rather than directly with counsel, that communication is treated as a disclosure to a third party, and the privilege is unavailable, even if the AI-generated content is later produced to the attorneys. The work product doctrine shelters materials prepared by or for counsel in anticipation of litigation. These doctrines are exceptions to the general rule that relevant evidence must be disclosed in litigation. In ruling on the government's motion, Judge Jed Rakoff concluded that the AI-generated documents did not qualify for either protection. The attorney-client privilege was unavailable because the communications in question were not between the defendant and his attorney. An AI platform is not a lawyer. It owes no fiduciary duties, and it is not subject to professional responsibility rules. Moreover, the court emphasized that the privilege requires confidentiality, and there was no reasonable expectation of confidentiality when using a publicly available AI tool. The privacy policy of the AI platform expressly allowed users' inputs and outputs to be used for model training and potentially disclosed to third parties, including governmental authorities. Under these circumstances, the court found that the defendant could not reasonably expect the communications to remain confidential. Finally, simply transmitting AI-generated outputs to counsel after they were created did not retroactively make them privileged. Long-standing precedent holds that sending non-privileged material to an attorney does not itself confer privilege. Even if part of the information originated from discussions with counsel, uploading that information to an outside service effectively waives confidentiality. With respect to the work product doctrine, the court held that the AI-generated documents were not protected because they weren't created at the defendant's sole initiative, not at counsel's direction. Work product applies to materials prepared by or at the behest of counsel. Independent client research, even if later shared with counsel, generally falls outside that protection. So what does this mean for you? Although Heppner arose in a federal criminal case, its reasoning extends well beyond that specific setting. Civil litigants, business clients, and individual clients alike need to understand that communications with consumer-grade AI platforms are unlikely to be privileged. Courts will examine whether the necessary elements of privilege are present, whether this is a confidential communication directly with counsel, and whether the communication was intended to obtain legal advice. And we'll look to the terms and privacy policies of those tools. For organizations and individuals, this ruling should serve as a stark warning. Uploading confidential or privileged information to public AI tools exposes that information to third parties and may undermine or waive privilege. It's not enough to tell counsel, I ran this by an AI tool and plan to share it with you. The courts will look to who initiated the use of the tool, whether counsel directed its use, and whether confidentiality was maintained. The takeaway is clear. When you're working with an attorney, you must allow your attorney to do their job. That means consulting directly with your counsel about legal issues, strategy, and analysis, not outsourcing that work to a consumer AI platform or other third-party service on your own. Doing so risks irreparably waiving privilege and exposing confidential discussions to opposing parties or even investigators. As generative AI becomes more prevalent in business and legal workflows, attorneys and clients must be aware of how traditional doctrines like the attorney-client privilege and work product apply in this new environment. Protective practices, including using secure, enterprise-grade tools under counsel's direction and explicit agreements regarding confidentiality, may help preserve privilege. But absent that, using public AI services for legal analysis carries real risk. If you have a question about how this ruling might affect your case or your use of AI in legal contexts, I encourage you to reach out to a qualified counsel. I'm Bryan Holman, and we at the Woodlands Law Firm are committed to helping you understand the law and protect your rights.